Hello and welcome to Business 360. I'm Shereen Bhan. The headlines we're tracking for you this evening. The government releases a draft of the revised data protection bill 3 months after withdrawing the previous bill. The new bill is solely focused on personal data. Data localization rules see some relaxation, penalties capped at 500 crore rupees. The government reserves the right to exempt entities from these laws in case of national security and public order. Twitter temporarily closes its offices to staff after a new wave of resignations hit the company. This comes after Elon Musk issued an ultimatum asking staff to commit to a hardcore work environment. Musk keeps tweeting through all of the drama, even posting memes mocking the expected demise of the platform. The union government amends the rules governing PSU banks. Managing directors and whole-time directors can now have a maximum tenure of 10 years. The amendments do not apply to State Bank of India just yet. Well, let's go straight to the top story. The government has released the draft of the revised data protection bill for public comments 3 months after withdrawing the previous version. Now, the revised draft provides for a data protection board whose instructions will be binding on data fiduciaries. There have been some relaxations as well when we talk about data localization rules. Also, the government reserves the right to exempt entities from data protection laws in case of national security and public order. Ashmit Kumar joins us now with the details. Ashmit, take us through the contours of this new draft bill. What are the key points of difference between the previous version and this one?
Well, indeed, it was much awaited. Now, it was in August of 2017 that a night judge bench of the Supreme Court held privacy to be a fundamental right. Today, 5 years later, and after many rounds of deliberations, committees and panels, we finally may have taken the penultimate step towards data protection regime. Now, the Ministry of Electronics and IT today released the draft version today, the draft bill. The third version of the bill is called the Draft Digital Personal Data Protection Bill of 2022. The deadline for public comments is December 17th. Now, as the name suggests, unlike its predecessor, this draft will focus primarily on personal data. The bill proposed by the parliamentary panel had proposed regulation of both personal as well as non-personal data. Now, the cornerstone of the bill appears to be consent. Data fiduciaries will have to give a detailed notice to users prior to collecting information. This notice will have to be in a clear and a simple language. Meanwhile, users on their part will have the right to give, manage and withdraw consent for sharing personal data. One big change that we are seeing is doing away of data localization requirements. Earlier version required critical personal data to be stored and processed domestically. This was a big pain point identified by the industry. The latest version, the centre will notify countries where data can be transferred, stored and processed. The earlier Raftar also gave a blanket exemption from compliance to the government. While the blanket exemption has been dispensed with, the centre will be given the power, in fact reserves the power, to grant exemption in cases of national security and public order. Under the draft, the government will also have the power to exempt entities from number one, issuing notices before collecting information. 2, centre can exempt entities from clarifying if they are collecting or processing information. And 3, government can also allow entities to store data indefinitely. These are the 3 exemptions that the government can notify. As far as the Data Protection Authority is concerned, well, this was the authority that was envisioned under the earlier version. It's now called the Data Protection Board. The earlier version provided for penalties of up to 4% of annual turnover. Now the penalties that can be slapped by the board are limited to a maximum of 500 crore rupees. The strength and composition of the board will be prescribed by the centre. The board shall also have the powers to summon persons as well as to inspect computers. Board can go ahead, in fact, their orders will be binding for data by fiduciaries and will carry the same weight as a civil court. Under the draft bill, fiduciaries shall be responsible for ensuring correctness of information that has been collected from data principals. Fiduciaries will also be required to take reasonable measures to ensure data security. In case of a breach, they'll have to inform both the board as well as the data principal or the data user. Now, the data fiduciaries shall also be required to delete information when the purpose for which it was collected has been satisfied. Data protection officers will also have to be appointed. One relaxation that in fact will be welcomed by the industry is that the bill provides for data transfer to other entities if allowed under contract. One concern, however, may be that there's a requirement which continues from the previous version, which is data fiduciaries will have to seek consent of parents in case of collecting and processing data of minors. It's called age gating. That's how it was red flagged by the industry. Meanwhile, As far as we are concerned, people like us, individual users, well, we can seek clarity in the form of a request, whether or not a data fiduciary is collecting or processing information. We will also have the right to seek deletion of data once the purpose is satisfied. We also have the right to access to a grievance redressal mechanism. Now, keep in mind that the government had withdrawn the earlier version, the earlier bill, to make the new bill simple as well as innovation-friendly. Now, has the government realized its goal? Stakeholders will be subjecting this draft version to detailed scrutiny.
The consent notice which comes from any of the applications, any of the platforms, will now have to be given in any one of the Schedule 8 languages of the Constitution. So that means the Indian languages will now be available to users for getting the consent notice. We have attempted to use the word she and her in the entire bill instead of he and him and his.
Well, that is the Minister for IT, Ashwini Vaishnav. It's been a 5-year-long journey. Let's see whether we finally see this bill make its way into the winter session of Parliament. Looks unlikely because the public consultation process is likely to continue till the 17th of December. We're now joined by former Telecom Secretary R Chandrashekhar, Gopal Jain, Senior Supreme Court Advocate, also with us, and Apar Gupta, Executive Director at Internet Freedom Foundation. Gentlemen, always a pleasure. Appreciate you joining us here. We are still poring over the draft bill that has just been put up for public consultation and public scrutiny this afternoon by the ministry. But Ashmit gave us a very quick but comprehensive snapshot of some of the key highlights. Mr. Chandrashekhar, let me start by asking you, for a layperson, is this a better version of the previous bill? Does it address some of the concerns that had been raised by industry as well as organizations like the Internet Freedom Foundation, which Apar represents? Citizens had raised concerns as well. Does this version of the bill address some of those concerns?
Yes, Shereen, in my view, this bill, this version represents a huge improvement on the earlier version. And I think the earlier version had tied itself in knots by trying to cover too many things like non-personal data, etc. It had also tried to make the provisions very stringent and had in the process, limited the efforts at innovation. It placed huge shackles on innovation. For example, there was very elaborate purpose limitation provisions, which a lot of people felt that startups' innovation would be hugely limited. So I think there have been huge improvements. It has been done by limiting its scope to personal data only and excluding non-personal data and limiting it to digital data and not physical data. That's a bit of an anomaly because if you look at it from a privacy point of view, there should be no difference between digital and physical. But whatever it is, I think these are certainly big improvements. The over-reliance on consent, which was there earlier, was not entirely consistent with India's reality. And I think it's a good thing that the bill has actually put some of that onus onto data fiduciaries and the data processors and made them liable if they cross the red lines laid down under the Act. There were also some idealistic but somewhat troublesome provisions in the earlier draft, like the right to be forgotten, which has now been replaced by a much simpler right to withdraw consent, which in turn requires the data fiduciary to stop using that data and so on. Similarly, the powers to exempt government agencies has been made much less sweeping. And I think that was a cause for a lot of concern for many people. And another, I think, significant step has been that the compliance burden in terms of appointment of a number of officials at different levels, that has certainly been also reduced, which would have been a huge burden on a lot of the startups. The localization stipulation also has been significantly relaxed for the better, in my view, because it has allowed data to move to other countries which are notified by the government. And also, the extraterritorial application of this law has been limited to cases where data fiduciary collects data, the personal data from a data principal in India in order to provide services to that individual in India. So I think this makes the ambit very, very clear and is far more understandable. It's far less complicated. And in my mind, it has struck a hugely better balance
Okay.
between protecting privacy and personal data and leaving enough room for innovation with the startups by making all of these changes. But this is based on a very quick reading,
Yes.
and perhaps a closer reading is required to look at some of the other details a little more closely.
I agree, and with that caveat, and that's what I pointed out at the start, this is the first cut that we are presenting for our viewers, and of course we will be poring over the fine print to see if there's anything that we've missed out on, but these are initial reactions coming in. Gopal Jain, what we're hearing there from the former DOT Secretary R Chandrashekhar is that this is a better version of the previous bill. This is more balanced. It does, of course, protect the right to privacy, but at the same time, it doesn't scuttle the right to innovation, which industry was pointing out as a cause of concern. He's listed out several aspects where we have seen some relaxations, the door and window, so to speak, being opened for data transfer, diluting the data localization norms, etc. How would you read the draft bill in its current avatar? What stands out for you?
So firstly, like everyone else said, it's fresh off the print. So we are just going by the flavor from what we can see. And I think it's definitely a significant step forward. And the hallmark seems to be simplicity and clarity. There's a clear objective, and that is something which can be achieved. So I think for me, that stands out. Second, in line with the principles of proportionality, which the Supreme Court has said, it strikes the right balance. Keeping the scope limited is another very important way of keeping it light versus making it heavy. Data flow, it permits, cross-border data flow, it permits. So that's a very good sign in line with our overall objective of liberalizing trading, which should include data. And ahead of India's G20 captaincy, I think smart laws like this, which strike the right balance, I think send a very good signal overall. And I think the single most important thing, as you said, which stands out in this is that views of all stakeholders have been taken on board. And that's a very important aspect in improving the quality of lawmaking. So these are the things which, in my view, stand out. Only one aspect, the steep penalties. I think the whole aspect of penalties and criminalization needs to be revisited. It must be very graded. It must be cautiously done, because when you confer that power, that regulators and courts have actually gone and always put the maximum amount.
Yeah.
So having some checks and balances on this becomes very, very important, because it is capable of misuse. And
no,
we saw
I
that
agree. But Gopal, I'm interrupting you because isn't this version better? Because it in fact caps penalties to up to 500 crores. The previous bill had spoken about penalties going as high as 4% of turnover. So wouldn't this be a better version than the previous?
No, I'm absolutely in agreement. I'm only saying the checks and balances and guidelines of how it's to be applied. For example, under the telecom license, there was a 50 crore penalty. So even if you sneeze, you go straight for 50.
Right.
So I'm saying some legislative guidance and guidelines as to how it's to be applied is the point I'm making. Obviously, it is far less than the 4% by having a cap. But from practical experience in implementation, in its application, like under the Income Tax Act, there must be a graded system. And all of that fits in with the principles which the courts have applied, which is of proportionality, of checks and balances, of some nexus between the nature of violation and the extent of penalty. So I'm only saying this broadly.
No, Gopal, I hear you. I hear you, and being a lawyer who specialized in telecom matters, I know you understand the pain of penalties only too well, so I hear exactly where you're coming from. But let me bring Apar into the conversation. Apar, from a citizen's perspective, does this protect our right to privacy, which the Supreme Court has guaranteed and said is guaranteed under the Constitution?
Shereen, the short answer to that is it needs to be seen after the act is actually enacted by Parliament. And there's a phrase I will use, and it's used 18 times in this proposal, as may be prescribed. The reason I say as may be prescribed is that much is being left to the finer details of its operation and practice, which will be then made by the central government. For instance, who will enforce this law? And that's the Data Protection Board of India. And if you look at clause 19, subclause 2, the strength, the composition, the terms of condition of appointment of the chairperson and board and members of the board will be as may be prescribed by the central government. So essentially, it may be that the members of this body which enforces the law against the government and its entities itself may not have that autonomy and independence, or may not have those service conditions, which may actually result in translating the protections within this law to actual practice. The other thing I think which is very significant and has been touched by the others is that if you look at the prior version of the Data Protection Bill, it had about 98 odd clauses which have been shrunk down to about 30 sections. And I think a fair amount of compression which has been achieved, this shrinking of the law which has been achieved, does result in simplicity, but it comes at the cost of detail, which again creates power for the central government to, without certain clear principles, to make conditions. For instance, we are talking about transfer of personal data outside India. That's clause 17. And it says it follows a white list approach, which is essentially the government will approve certain countries for transfer of data outside India, rather than the default being that there can be international data flows. And what may be the conditions under which the government may prescribe it is not also stated. The clause states the central government may, after assessment of such factors, and there are no factors given in this clause. So I have somewhat of a critical view about it. This is not to say there's some improvement. There is some improvement. There is an obligation on data fiduciaries to notify users of data breaches. This was not there in the earlier version. But as others are saying, I will do a much more detailed reading around this. But I think after 5 years of conversation around data protection, we are hoping for some enforcement and action and actual remedy to actually come through at this point in time.
Preempted my question, because that is exactly what I was going to ask the three of you, and I know Ashmit will weigh in on that as well. You know, as you point out, a lot of what is there in the bill is yet to be prescribed and will be prescribed by the government. But it's a very important point that you raised there as far as the Data Protection Board is concerned. And let me get Mr. Chandrashekhar to comment on that before I get Ashmit in. Mr. Chandrashekhar, the Data Protection Board will have powers to summon, inspect documents, computers, etc., may issue binding directions to data fiduciaries, and the decisions are equivalent to a direction that's passed by a civil court. But as Apar is pointing out, we don't know about the composition. We don't know whether these are going to be government officials, retired government officials. Do you share the concerns raised by Apar that a lot of the bill and the rules are yet to be prescribed, and hence we don't really know?
Yeah. I would only agree partially, and the reason is as follows. You know, we are here trying to strike a balance between the specificity which we require a law to have and the kind of agility and adaptability which any digital law may require. So you don't want too much of detail in the law, because time may very quickly render such provisions, you know, inconsistent with the realities around. The question is, and I would not look at a law on the basis of the rules which might be framed, because the same law, you can frame different rules at different points in time. So the key question is whether the central principles that the law seeks to lay down, whether they are clear enough. You know, whether a fine limit is 500 crores or, you know, 100 crores or 1,000 crores is, to my mind, you know, thing which could be specified later. It could also be that, you know, over time, these numbers change. Any absolute number in a law in monetary terms has its own challenges as well. But I think it was necessary to send a signal as to how big the business risk, if any, could be. And therefore, you know, prescribing an absolute number was perhaps essential. But I think one should not wait for the rules to decide whether this is a good law or not. Assume whatever you want under the rules, and if you can do a lot of things which are not good, then it's still not a good law. So I would say that as long as the flexibilities that have been provided can be used to enhance this balance, continuous balance between privacy and innovation and convenience of users, I think that would still, to my mind, constitute a good law. But if there are any of these basic principles which are still not clear under the law, then that is what will perhaps need to be improved. And that's what this whole consultation process is expected to achieve. So, Shereen?
Sure. Right. A very good afternoon to all of our panelists. Ashmit here from the Delhi studio. Apar, let me come to you. In many respects, when you look at a data security framework, the GDPR is often seen as the benchmark. And one of the reasons for that is that it is considered to have the teeth to bring in some accountability as far as big tech companies are concerned. My question is on the issue of penalty. The GDPR provided for 4% of annual turnover. The earlier version provided for 4% of annual turnover. This version accounts for only 500 crore rupees. The reason I ask is, and that's in light of a very recent incident where Google sought to make a settlement payment of about $400 million in the US for privacy violations. And that, in fact, easily accounts for something like 30,000 crores. So is this a case? Can one make a case that perhaps this latest version may not have enough teeth to instill that sense of accountability that the government may be looking for?
So when I look at penalties, Ashmit, I don't look at the quantum or the severity of the penalty. I see the certainty of the penalty. And that's what most lawyers or people who are public in policy would like to do, right? If something bad happens, firstly, something bad should not happen. There should be a voluntary system of compliance because any society orders itself on the basis of people following the rules, not because there are breaches of the rules. And secondly, when there are the breaches of the rules, there's a certain level of certainty that there is a swift administrative action or a judicial action which follows to cure that breach. And here I look at the body which will enforce it, which is the data protection board, which is being created right now. So a lot depends on it. That's one. The second is just in terms of the quantum by itself, I think percentages work. But then again, I think what is good in this law to a certain extent is that there is a system of a voluntary undertaking which can be given by a company. We have seen these kind of framings which exist in other regulatory systems, such as under the Federal Trade Commission, where voluntary settlements can be made, and they also are cash penalties accompanied through these voluntary settlements. So it's kind of nice that it can inspire that kind of compliance even when unintentional breaches do take place. I do think that the financial penalty is also graded and proportional, because if you look at clause 25, the penalties for small and medium businesses may look incredibly large, which are about 500 crores, can basically kill a business in India. But for big tech, it's very, very insignificant. And I think here, the ingredients which are given, such as the repeated nature of the non-compliance, the type and nature of the personal data, the gravity of the non-compliance, etc., they are all very, very significant. So I do think there's some proportionality built in. I would have liked a percentage because that gives flexibility, but I also am aware that the schedules which prescribe the penalties, the central government has the power to amend them at a later point in time. So I think focusing on the penalties by itself as a percentage amount or as a fixed sum is a bit of a distraction. What we should figure out is that how will they be imposed? Will there be certainty? Will there be responsiveness? How will the body function by itself? Given our experience with the Competition Commission, which has come much more recently, has been through years and decades of work by itself. It's not come through just in the last 3 months, right?
Sure. Mr. Jain, if I may get your quick thoughts on the issue of social media intermediaries. There were concerns on a heavy-handed approach where there are overlapping legislations. What is interesting is that, and this has been a complaint that has been coming from the industry, that look, we can't be regulating the intermediaries under the IT Act as well, and then subsequently under the Data Protection Bill as well, which is what the earlier version sought to do. Just your quick take on this distinction that this bill makes. The earlier version provided for regulation of intermediaries as well, devices, mobile devices as well. All of that has been taken out of the ambit of the draft version, at least. Your take on that?
Yeah, so like we said, there's a good cleanup act, but on the larger point, we saw, like, for example, with the new draft of the telecom bill, you cannot have overlapping jurisdictions because that results in turf wars and therefore uncertainty and therefore heightened risk. So I'm a firm believer in the fact that you must have one comprehensive framework, and perhaps like we have one India, one market, one rate, we should have one regime for every sector. We have seen in the past fights between TRAI and the Competition Commission in the telecom sector, SEBI and electricity regulatory commissions in the electricity sector. So I think new age laws must prevent jurisdictional turf wars, and therefore drawing the Lakshman Rekha or the line in the sand becomes very important. And going back to a point which Shereen had asked one of the earlier speakers, therefore it's very important to have experts man this data protection board. And perhaps the time has come when it comes to new age laws to also prepare the draft of the rules and place them, because one must have a comprehensive, complete picture. So as prescribed, what it's going to be should also be dovetailed at this particular point in time, so people can comment on the entirety of the proposed new regime. And I remember in the call drop judgment, the Supreme Court really exhorted Parliament, saying, look, time has come to revisit this issue of delegated legislation and rules, etc. So I think having that full picture, the big picture, which dovetails everything together, is what is important to have upfront visibility for all stakeholders, and that will make implementation as well easier, and people can give informed comments on the full regime as it will be.
Well, that's an important point that you make there, and that links it back to what we heard there from Apar as well as Mr. Chandrashekhar on the need to look at the composition of the Data Protection Board very carefully so as to ensure the actual effective execution of this new law. But Mr. Chandrashekhar and Apar, I'm going to give each one of you a minute exactly. The consultation process is on till the 17th of December. Mr. Chandrashekhar, if you were to make the top 3 suggestions on what should be refined, what should be tweaked, what should be changed in this version, what would those be?
Well, I think it's approximately at the right place. So I wouldn't have any, top of the head suggestion at this point to make any change to what has been suggested. There can be some fine tuning, but I wouldn't put a headline item for the change at this point. Shereen?
Okay, Apar?
So actually this law is a Cliff Notes version of the earlier law. So there's a lot of opportunity. I would just ask people to do a search on the document as may be prescribed. Look at whether the anchoring first principles are present there, and if they are not, put them in. The other 2 places where I think people can focus some energy towards developing them more is Section 18, which is the exemptions clause by itself. Yeah. And the second one is Section 19, which is the Data Protection Board of India, because quite often it's the regulatory body which enforces the law, which is our real practical experience of how it's implemented.
Well, Apar, I'm going to borrow that from you, because I think what we've done in this very sharp 30 minutes is give our viewers a Cliff Notes version of what this new draft bill holds. So thanks very much, Mr. Chandrashekhar, Gopal and Apar for joining us. And you said 18 times as prescribed is mentioned in the bill, right, Apar? I'm going to go with you on that, 18 times. And we promise to keep this dialogue and this discussion continue here on CNBC-TV18. But we really appreciate you joining us here on today's version of Business 360 with what you make of the new draft bill. Thanks very much for joining us. We're back in a minute with our Friday favorite, the Editors Roundtable.